present a parental alienation case without experts? Yes, you don't have to have an expert in a parental alienation case because parental alienation at its base is simply bad behavior. You have to find out what happened, and that means hearing the stories, comparing the stories, making an assessment as a judge of what actually happened, and then determining whether that constitutes parental alienation. Everybody knows the label parental alienation at this point. Not everyone can tell you what it is, and it's not statutorily defined, at least not in Michigan or in the States, but these are words that are commonly understood, and you can find them in the dictionary. So it's just a matter of looking at the behaviors, what's been done, what's been said, and determining whether it falls within the scope of that terminology. Because it's what happened that really matters, not what you call it. A case which was filed in my court 15 years ago. Parties went through a contentious divorce. They had 3 young children at the time, and the evidence showed that the children were alienated from their father, but not entirely by mom's own doing. Dad's own behavior played into that. And so the parties went through a 7-day trial, and I made a determination that there was parental alienation, but there was also estrangement attributable to dad's own behavior. I ordered parenting time in custody and also counseling. It was not appealed, and so I didn't hear anything more about it. And as it turned out, father stopped exercising parenting time and did not see his children for 3.5 years. And when he came back to court, I learned that what he had done was try to improve himself. He had gone through 3.5 years of regular therapy and counseling. He had taken parenting classes and done a variety of other things. And he came back to court with an attorney asking for restoration of his parenting time as a changed person. And it took a while because, of course, mom and the kids weren't ready to believe it. But over the course of several hearings, we ordered reunification counseling. That began, but it did not go smoothly. Mom ended up being held in contempt of court, and ultimately dad filed a motion for change of custody. And after another trial, he won. Unfortunately, as many years as it took to go through all of that, his 2 older children had aged out of the court's jurisdiction, and so the change of custody applied to the youngest child. And after I made my decision in that case and a judgment was entered, mom filed an appeal to the Michigan Court of Appeals, and they took the case up and they issued a published opinion. So that was the first published opinion in Michigan dealing specifically with parental alienation. No one ever goes to jail for parental alienation. It's the violation of court orders that can land them in contempt of court. And it doesn't happen often because judges will remind people that violation of court orders can result in jail time, and so most people try and avoid that. We don't follow every single case. We issue orders and expect that they're going to be followed. If an order requires payment of child support, we have an office in the court called the Friend of the Court. They track those payments and they take action if the payments don't come in. With respect to parenting time disputes and custody disputes, they rely on complaints being made. There are frequent complaints made, and those are investigated by our Friend of the Court office, and they will bring contempt motions on behalf of the parties before the court if they feel that it's worth pursuing. The rules of evidence say that the court can take testimony and opinions from an expert who is qualified if the opinion will be helpful to the court. And in many cases, that opinion can be helpful because the expert can review the entire case, can evaluate the evidence, and present it to the court in a format that's more easily understood. I have never had an unrepresented party present evidence using the 5-factor model, because they don't know about it and would have difficulty doing it anyway. But attorneys will call in experts who can do this, so that it is helpful to the court. It's just not required. As far as parental alienation is concerned, the issue and the facts that support it have been around for decades. In fact, there are cases that go back over a century where where judges have talked about a parent poisoning the mind of a child against another parent. We're simply a little more sophisticated in how we talk about it these days, and if the evidence supports it, the finding can be made. I don't think junk science is really a credible objection to claims of parental alienation if they're properly presented. Every state, and in Canada as well, have a list of what they call the best interests of the children, and that's a list of factors that the courts have to address in order to determine what's in a child's best interest. So Michigan has a list of factors. Every time I review a custody case, I have to go through those factors. The best advice that I can give to a targeted parent is to stay calm, stay committed, don't quit. Targeted parents are often set up in a way that the alienating parent and the alienated children will provoke and poke and push, and it requires a tremendous amount of patience and fortitude on the part of an alienated parent to stay calm. Don't react with anger or upset, because that will just feed into the narrative that the children have already been fed. And then the other piece of advice is one that I heard earlier in the conference today: don't quit. I've had cases where I've ordered parents into counseling. The biggest drawback that I have in my court is that the state does not fund that counseling. I have to order the parents to pay it and determine which parent is going to pay how much, you know. So that can be a limiting factor. We have some low-cost options, but there's not enough of those. Judges have, in general, a big hammer in the form of contempt sanctions, but not much funding to provide necessary counseling, family therapy, and that kind of thing. I think there's a widespread understanding of it. If you were to ask the question, how many lawyers have real expertise in the area, I would say the percentage is much lower. But I think all the lawyers that come into family court have some awareness of it. And I try and educate along the way where I can. Unfortunately, I don't get much opportunity to do that until it's time for me to issue an opinion, a final decision. In family court, the case is done once the final judgment's entered and the appeal period has expired. And then the case is considered closed. However, when there are children involved, the court retains jurisdiction to enforce its orders and can modify custody or parenting time or child support if there's been a change of circumstances or other proper cause to justify it. And so that means that depending on the age of the kids at the time of the divorce, the case is going to keep coming back if needed until the youngest turns 18 and graduates from high school. So a final judgment in a divorce case is not always final as far as the children are concerned.